We'll call to order the Judiciary, Finance, and Policy Committee. Today is January 16th. Can I have a motion to approve the minutes? Representative McNamer moves the approval of the minutes from yesterday, January 15th. Any corrections or changes? All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Remember, today, first, we have a presentation from the Board of Public Defense. Each of the presenters today are going to have 30 minutes to present. So is Kevin Kyer going to go first? Please come to the table, state your name for the record, and go ahead. Are we having technical difficulties?
Madam Chair, that's why I always pass out paper.
Great. If you want to just go ahead and get started,
Sure.
The staff can work on technology.
Madam Chair and members, my name is Kevin Kyer. I'm the Chief Administrator with the Board of Public Defense. And with me today is John Stewart, our State Public Defender. And I think John's going to start out here. I'm going to try to go after him, although you can hear my voice is starting to fail already, so we'll see how far I actually do get in this.
Madam Chair and members, good afternoon. My name is John Stewart. I'm the State Public Defender. I want to begin by saying I appreciate our being asked to talk in part about why public defense is important. And I'm going to talk about that for a minute, about why we do what we do, and then Kevin is going to talk about how we do it. So my theme is, why is public defense important? First of all, I'm guessing that just about everybody in this room would say that the American justice system is the best justice system in the world. And then if people were asked, well, why is that? Why do you believe the American justice system is the best justice system? They would point to the American justice system honors individual rights, and the American justice system is based on the principle of equal justice under law. That is really what public defenders do. If you believe everyone deserves a fair trial, that's what public defenders do. If you believe that whether you are very poor or if you have plenty of money, you should still have an equal, fair day in court, that's what public defenders do. People with no money, people with lots of money, have the same rights if they're accused of a crime. So we believe that public defense really is the implementation of some of the things in America that we're the most proud of that are in the Bill of Rights. Secondly, in a sense, public defense is a quality control part of the Minnesota justice system. We're the people that look at a case and say, well, wait a minute, could that witness really see what he says he saw? Was that material that was tested in the lab really tested correctly? There's been a lot of publicity about the St. Paul drug lab here in the last few months, and that just came about because public defenders were concerned that people were cleaning the equipment and working off of a protocol and getting appropriate training and so on before they issued findings that would lead people to serious consequences. We have a system of checks and balances, as you all know very well, and we're one of the kind of checks in the criminal justice system. Finally, we do what we do in order to have the court connect with the individual. Now, I've just been schmoozing with some friends of mine who are prosecutors, and I know that they're very concerned about the justice system, and that's great. We're the people that actually talk with the person who is the defendant in the case. We're the people that explain what their options are, what could happen to them, talk with them about how they want to handle the case. You know, a lot of studies about courts have been done that say that court orders get a lot better compliance if the defendant feels that he or she has been listened to, and if they've had somebody stand up for their side of the story, and if they've had somebody explain to them what the court told them to do, what happened in court, what am I supposed to do now. That's how you get a more effective court, and that's what public defenders do. We're moving on to our agency purpose, and it's exactly those basic values carried out through a responsible and independent and efficient public defense system. We have in America a set of 10 organizing principles for public defender agencies that was developed by the American Bar Association about 15 years ago. And the number one principle is that public defense should be run by an independent board that is nonpartisan and is widely connected to the rest of the community. So that, for instance, right now, I should say these are not the actual pictures of our board members that you're looking at here. These are not really them. But we have 3 non-lawyers appointed by the governor. One of them is a human resources director. One of them is somebody who was the host on Almanac. One of them is a senator who was also a high-ranking police officer and U.S. Marshal. He's not in the Senate anymore. He went over to become U.S. Marshal for a while. And then among the 4 attorneys, we have a retired Supreme Court justice. We've had a retired Supreme Court justice on our board now for about, 12 years. We've got a retired district court judge. We've got the former president of the Minnesota State Bar Association. We've got a woman who runs an independent criminal defense practice in Rochester. So we have people that are connected to the bar and to the court and are independent, nonpartisan, helping us to run this agency. And Kevin is going to start talking with you about how they do it.
Representative Cornish has a question. Representative Cornish.
Madam Chair, just curious, who is that Marshall guy you were talking about?
Mr. Stewart.
Madam Chair and Representative Cornish, it's Mike McGinn.
Oh.
Former Senator McGinn.
Where he went.
U.S. Marshal. He was, I think, a captain or something in South St. Paul. Or deputy chief.
He was captain in St. Paul.
Captain in.
Please go through the chair.
Oh, thank you.
Madam Chair and members, as John indicated, the board really has 4 duties. They set the standards and policies that we operate by. They appoint our district chief public defenders, our chief appellate defender, and the state public defender. And they allocate the funding that they receive or that we receive from the legislature. They have 5 major goals, and those are on page 8 of your handout that support that mission that we talk about. Continual training for all staff, creative advocacy, client-centered representation, being a full partner in the justice system, one of the things that you see us hanging around here for a lot, and the recruitment and retention of excellent staff. On the district level, district public defenders provide constitutionally mandated service in felonies, gross misdemeanors, and juvenile delinquency cases. They also provide statutorily mandated representation for children over 10 in child protection cases. On the appellate side, we provide services in criminal appeals, post-conviction proceedings, and supervised release proceedings, or what we used to call parole revocation hearings. The board also funds 4 public defense corporations. We're basically the pass-through agent for the legislative appropriation for the public defense corporations. These are 4 nonprofit corporations, 3 of which for sure started before we even had a public defender system, which provide service in about 4,000 cases. But for the corporations, those cases would be public defender cases. The budget, Madam Chair, is roughly $67 million a year. About 90+% of that is on the district level. Another just under 7% in the appellate office, and our administrative office is just under 3%. The budget itself is, as you know, I think you've seen this from some of the other agencies as you've seen, about 90% of the budget is personnel. Another 7% of that is what we call our mandated costs, which are things like mileage reimbursements, phones, rent, those things where we have a lease or some kind of contractual obligation to pay. The corporations make up about 2%, with all other spending about 2%. Things like transcripts, printing and copying, those kinds of things that generally are caseload related or driven. We have a total of 687 staff people. This includes employees in Hennepin and Ramsey County. When the state assumed the cost of public defense back in the late 80s and early 90s, the county employees were grandfathered in as county employees. Any new hires after that point were hired as state employees. So we do have a number of folks in Hennepin and Ramsey County that continue to be county employees.
Do you know how many people that is, Mr. Carr?
Yeah, Madam Chair, there are, on the attorney side, there are roughly, I want to say 50 in Hennepin, and I think we are down to, I want to say less than 20 in Ramsey, probably like 18.
Representative Lesh.
What was your peak,
Mr. Carr.
Madam Chair, Mr. Kyer? What was your peak? When you,
Representative Lesh.
what was the highest number of attorneys you had at one point?
Mr.
Madam
Carr.
Chair and Representative Lesh, you know, I would have to go back and look. I know at one time, prior to 2008, we had 422 full-time equivalents.
Okay.
422 or 423.
Okay.
Now, whether or not that was the highest, I'd have to go back and look. We may have had more than that in the early 2000s, but not by a lot.
Okay. Thank you.
If you could actually get us staff number ratio, including the county people, and not just so that we can get a clear picture of how many staff you've had,
Oh, absolutely.
attorneys versus none.
Yep.
Mr. Kyer.
I've got it with me, but I can put it in a better format.
And if you could
Sure.
just send it out, and we'll make sure the
Absolutely.
members of the committee get it.
Madam Chair and members, if you could see on that slide, about 43% of our attorneys are part-time. And this is really important because outside of the metro area, they're over half the staff is part-time. They are state employees. They are 75, 50%, or 25% time. They take whatever cases are assigned to them. And by and large, they cover their own office overhead. So it's a very cost-efficient way of doing business, particularly in the, you know, as I said, in greater Minnesota. We do have a small stipend that we pay them for overhead. It's $3,600 if you're a three-quarter timer. It's $2,400 if you're a half-timer. Those of you who have run a law practice or have been involved in that at all, you know that's a pretty small amount compared to paying for rent and secretary or associates or whatever you might have. So the other big piece that they handle are our conflict cases. So when we do have those multiple defendant cases, it's very easy to move those cases around when we have those part-timers. We are the largest user of the court system. On the trial level, we have roughly 150,000 cases a year, roughly 1,000 appellate files that are open, and almost 4,000 supervised release or parole revocation cases every year. On page 18, you see kind of our breakdown of our caseloads. Roughly, 69%, almost 70% are misdemeanors or gross misdemeanors. That's a little deceiving because when you look at the workload, one of the things that we do is we break this down into case units so that we can compare workloads across district lines and even within districts, because obviously a felony case takes more time and more effort than the misdemeanor case might. When you break that down into our case unit, which is roughly the equivalent of a misdemeanor, you see that the workload is actually about evenly distributed between the felonies and gross misdemeanors, and then misdemeanors after that. As John mentioned, I think the workloads and the caseloads are controlled by outside factors. Two of the biggest ones are two Supreme Court cases in Minnesota. The first one is Zubiak v. Mott. In that case, the Supreme Court stated that public defenders may not reject a client and are obligated to represent whoever is assigned to him or her, no matter what their caseload is. The second one is relates to appellate casework. In State v. Deegan, we actually came to the legislature for a statutory change to give our appellate office some discretion in some of the guilty plea cases that they handle. And Madam Chair, I think you were, I don't know if you were on that bill, but you were certainly here at the time. And that bill was passed. Ultimately, Mr. Deegan went to the Supreme Court, and the court found that that was unconstitutional, that basically everybody has a right to one bite at the apple, if you will, on the appellate side. So there really is not a lot of discretion related to what cases we take. In fact, there's none. On the appellate side, there are some things that the office does in terms of looking at caseloads or at cases, but it's very limited given the situation with Deegan. As we move forward, Madam Chair and members, if you look at page 22, the legislative auditor did a program evaluation back in 2010. And one of the things that they found, and their main finding actually, was that high public defender workloads have created significant challenges for Minnesota's criminal justice system. Those of you who have been on the committee before and have been in court, I think you see a lot of that. Public defender cases are too high, resulting in public defenders spending limited time with clients. What they found in their field work was in a lot of places, public defenders basically had about 10 or 15 minutes to sit down with the client, explain the charges, explain the plea to that person, and try to get that case resolved. Compare that to basically what should be happening according to our national standards, which would be somewhere around 4 hours that somebody should really be putting into a misdemeanor case. Now, again, not all misdemeanor cases are that complicated, but some of them are. So, Madam Chair, I know you want to talk a little bit about the audit report. I was going to take that time to do that now, to go through some of the other points. They are on page 23. We also, I think, have a memo in your packet where we responded to all of the recommendations in the audit report.
So, members, I specifically asked the public defenders to talk about the legislative auditor's findings, and then I, of course, have now limited the amount of time that they get to speak. There was a legislative auditor's report that was done, and it highlighted a number of things. And so you prepared a memo, you stated, responding to each and every one of the
there were,
items.
I think, 8 total that were directed to the board. There were others that were, frankly, directed at the legislature. And the memo deals with the 8 that were directed at the board.
So, Mr. Kyer, you can feel free to talk about that to whatever extent you want, but members, you would have the opportunity to read it, and they're going to come back before us. So we do have a number of times to talk about it. I just wanted to make sure that prior to us talking about your budget, you had the opportunity to talk about those issues.
Sure.
Mr. Kyer.
Madam Chair, folks have that memo. I'm hoping that you do. I guess you do. Or,
Do we have it? No. No, we don't have it.
Okay.
You'll get it to us, right?
I did drop it off with the packet of the presentation.
We will make certain.
If not,
the
we will
committee
certainly
gets
get it to you.
All right.
Madam Chair, the 5 main ones, or and I'll take just a minute to go through some of these. The first one was stricter criteria for the structure and content of district chief work plans and performance evaluations. And we agreed with the auditor on that evaluation finding. In fact, we had started to do that prior to the auditor doing their work. The establishment of standards for measures of quality representation of clients. Our board did meet and pull those together. They have adopted those, and we are now in the process of incorporating those into our performance evaluations. A third one was the improvement of management practices to ensure active supervision of public defenders. One of the concerns was, particularly for part-timers, is they weren't getting the support or the supervision out in greater Minnesota that they might in the urban area. A lot of that has to do with geography. A lot of it has to do with our managing attorneys carrying full caseloads. And a lot of these folks are our most experienced attorneys, and frankly, they're reluctant to give up those caseloads because they know that if they give them up, they're just going to, those cases are going to go to the folks that they supervise. What we have done is to start gradually moving those folks down to 50% caseloads, which is what our standards call for. So we are in the process of doing that. The other thing that we have done with those folks is we have moved some positions around the state because we've now set a standard for the number of people each manager should be supervising. And so that has been evened out across the state, and we've moved positions back and forth across district lines in order to accomplish that. So we are moving in that direction. I will tell you this is a challenge for us, and it continues to be a challenge for us, just for the reasons that I stated. The other issue that we have, frankly, is if we have somebody gone on vacation, sick leave, if they quit, the managing attorney is the one in those rural areas that has to pick up that caseload. So it's a difficult task for us, but we're moving toward it, or we're at least trying. So the last one I just want to touch on briefly is that the auditor found was the long-range planning efforts to talk about or estimate future staffing needs. We have established a long-range planning committee that's taken on a number of these issues. One of them was our ratio of full-time and part-time defenders and our full-time offices. That resulted in consolidation of 3 of our full-time offices that we just felt weren't as cost-effective as maybe they could be. They've reviewed the availability of support staff, and we're looking at that in light of some of the changes that are going on in the court. Are there other things in cases that support staff can be doing rather than attorneys? The other issue in that was recruitment and retention. We've talked to a few of you about this. Retention is a tough issue for us. Salaries are an issue. Caseloads are an issue. In the rural areas, recruitment and retention, particularly for part-timers, is an issue. It's difficult to lure somebody out to an area to say, gee, we'll give you a part-time contract or a part-time job, but you have to hang out a shingle and start practicing law in a private practice, and especially with caseloads the way they are. So we have had, that continues to be a difficult issue for us. Madam Chair, on page 24 you see some of the other issues related to workload factors that were identified by the auditor. And I don't want to spend a lot of time on these, but they are issues that we have run into. Legislation. You know, there have been a number of sentencing enhancements over the years. Yeah, I know that. Collateral consequences, which a number of you have talked about in this committee for a while, which make resolving cases more difficult. Language and cultural barriers. You know, the face of Minnesota is changing. We all know that. And that's become an issue. And the issues of mental health and chemical dependency. Our defenders will tell you that 70 or 75% of the cases that they see or the clients that they see involve chemical dependency one way or the other, and or mental health issues. And that's just, you know, that's just it. And the court's dealing with those same issues. Other issues that involve the workload issues. We have a couple of Supreme Court decisions relative to relative to immigration consequences, another one relative to plea negotiations that require that folks do their due diligence, put in their time so that they are not found to be ineffective. And as John mentioned earlier, the increased use of scientific evidence. The St. Paul Crime Lab is a big example. It got a lot of headlines and all those things, but every day there are more and more issues related to scientific evidence that lawyers are now have to be trained in. Forensics, DNA, drug analysis, a number of things that only are going to expand. I mean, this is only going to get, be a bigger and bigger piece of what we do, and frankly what prosecutors do as well. So, John mentioned earlier the kind of the interconnectedness a bit. Local, state, and federal decisions that impact us. And again, I'm not casting aspersions on any of these things, because I think they're good things by and large, but they do impact public defense. When you create a judgeship, that's another calendar that we have to cover. It's another calendar, frankly, that prosecutors have to cover. Again, it's not a bad thing, but it is one more calendar where you got to find somebody else to be in. We've seen an increase in federal funding for mortgage fraud cases. Specialty courts. Again, the specialty courts, particularly the drug courts, have been very successful. But they require a lot of time. They require a lot of extra hearings that people have to go to. Same with the veterans courts, mental health courts. Every once in a while we see federal grants for DNA testing. I know Hennepin County got a chunk of money for doing DNA testing on cold cases. So those cases all of a sudden now are brought forward, and those are things that we have to deal with. The development of regional jails, again, a good thing for local units of government, but if our defendants are now held in the regional jail, they might be 100 miles away from where their defense lawyer is. We have a jail in St. Louis County, for example, that's in Duluth, but we have defenders on the range, so they've got to run from the range to Duluth to see their clients.
82 miles.
82 miles.
Are you using more ITV then? Is that available to you for some of those challenging distance issues? Mr. Stewart.
Madam Chair, we've got 2 ITV projects going. We're working with Sherburne, Benton, and Stearns County on a tri-county program to have as many hearings as we can on ITV, and we're also working with the Department of Corrections for folks who are in prison to have their cases handled by ITV so that you have less transportation and security costs for the department. For the inmate, it means that their programming isn't disrupted. That's going to start running in February. We're going to do our first cases between Lino Lakes and Anoka. Virginia Murphy is working on that. That's going to be happening next month.
And so then would the public defender be in the courtroom, or would the public defender be at the prison with your client?
In some of these cases, we're going to have a secure phone line, Madam Chair, where the public defender will have a chance to explain everything to the client. And we're going to start with cases that are basically uncontested, but where there has to be a hearing, like Randolph requests and things of that nature.
Thank you. Please continue.
Sure.
Madam Chair and members, I know we're running close to time, so a couple of things. I think, we've been a good steward of public funds. We believe that. About 97% of the board's budget is direct service to clients, as I mentioned. About 85% of our staff is involved in the direct service to clients. Lawyers, investigators, paralegals, those folks, and we can get you those numbers. A couple of other things that we've done. We've moved our data entry away, our case opening exercise away from our part-time public defenders and given it to our support staff. We're not paying lawyers to do clerical work anymore, which was, again, one of those issues where, you lawyers on the board, or on the committee, you're a little possessive of your cases. This was a big hurdle for us because they like doing their own stuff and being in control of their own things. I mentioned we consolidated some of those offices. We've expanded our use of volunteers and law students. The other thing, which is related to that audit report, is we've updated or replaced our time and case management system to capture a number of the elements that are now in MNCIS, and also to record better the cases. Right now, what we have done, or one of the issues that the auditor found, was they wanted to see a different standard for the urban area, the rural area, and suburban area, just because of the way the practice is different. Well, our data management system wasn't able to do that before. We have now retooled that, and we have an internal resource allocation policy now that does take into account geography, and also does take into account the seriousness of felony cases. So our ratio, for example, for our caseload standard for presumptive commits is different than those felony cases that aren't presumptive commits. So that Crim-Sex 1 case does get more weight than, let's say, a felony check writing or felony theft. So we did take that to heart. The audit report wanted us to do a full-blown weighted caseload study again when money was available. Frankly, that would have cost us an awful lot. What we did instead is we looked at a number of states that have state systems and took the best, if you will, of those places, many of which did a caseload report since the last one that we did. And we came up with what we think is a better target of resources. And that will go into effect. We're now collecting that data, and that will go into effect with our next budget cycle, July 1st. So we're hoping that that's going to help us there.
So how close are you to an ideal caseload standard, or even a minimum standard?
Madam Chair, and we're going to talk about this obviously at the budget hearing. Right now, we operate with about 58% of the lawyers that we need to do the job up to the national and state standards. So instead of, theoretically, if you needed 100, we're at 58.
Questions from members? All right. Thank you very much. Oh, Representative Lesh.
Not so much a question, but more of a comment. A lot of senior members of this committee know how I love to beat up on the public defenders. It's great fun. However, being a prosecutor for 12 years, I just have seen the effects of what has happened to you guys in funding, and frankly, it is unconscionable of what your employees end up having to do in court. And it's not serving any of us who are interested in law enforcement or law and order. It's not serving any of us very well at all. The 58% number sounds bad, and rather than some members think, well, we're getting a bargain, we're not, because the effects of that are detrimental to the entire criminal justice system, including prosecution. So I would ask members to be mindful of that as their budget comes up in future weeks.
Thank you. Representative Bruskowski.
Thank you, Madam Chair. I guess this question, Madam Chair, would be for you. The discussion around the forms and the qualifications for obtaining public defender services, should we save that for the budget discussion? I know I've had a little bit of discussion with Mr. Kyer on it, but maybe that's later, Madam Chair.
Representative Bruskowski, I think we will have additional discussions about that. I have carried bills regarding some of that stuff previously. I'm not sure if there's going to be any legislation on that issue. Is there any legislation?
Madam Chair, we're not proposing any.
Okay. But yes, if we could save those discussions for the budget discussion, or if you have a question that you can ask them for information, they can get it to us ahead of time, and then we'll be more prepared to ask some of those questions as well.
I will do. I'll follow up with them, Madam Chair. Just realizing there's like 3 different bullets in the overview of the OLA report that deal with that, and may dig into that a little bit and talk with Mr. Kyer some more. Thank you.
Thank you, Representative Bruskowski. All right. Thank you. And you will be back. The governor's budget comes out next Tuesday.
Okay.
So I think we'll start hearing parts of it on Wednesday. So.
Thank you, Madam Chair and members.
All right. Thank you. The next item on the agenda is the Guardian Ad Litem Board. Please come to the table, state your name for the record, and let me know who's going first.
Good afternoon, Madam Chair and members of the committee. I'm Suzanne Allegro. I'm the Guardian Ad Litem Program Administrator. With me is the Chair of the Guardian Ad Litem Board, Judge Leslie Metzen, and then we have a Guardian Ad Litem from Hennepin County, Melissa Olson. Judge Metzen will go first.
Go ahead, state your name for the record.
Madam Chair, members of the committee, I'm Leslie Metzen. I'm currently serving as the Chair of the Guardian Ad Litem Board, and in my work life, I was a district court judge in the 1st District in Hastings for 23 years.
If I could interrupt for just 1 second, if you could point the microphone at you, at least, not only for those in the room, but they are recording this.
So I served as a judge for 23 years. And before that, and as a judge, I had a chance to preside in both juvenile and family court, so I used the services of Guardian Ad Litems on a regular basis. And as an attorney, back in the days long ago, I actually served as an attorney for kids who were the subject of, then they were called abuse and neglect cases. So I've got a pretty extensive history in working in this area, and just want to touch briefly on why Guardian Ad Litems are important to our system. They advocate for the best interests of children who are in court and the subject of proceedings either because they are abused and neglected, or because their parents are getting a divorce, or there's been domestic violence in their home. And the Guardian Ad Litem serves as an independent voice and can provide information to judges that is absolutely crucial in judges making good decisions that serve the best interests of children in these various cases. We operate and respond to both federal and state mandates. Guardian Ad Litems are required to be part of these cases. And as a board, since our creation, we're committed to providing the highest quality of services for each child that comes into court. We're committed to providing an adequate number of Guardian Ad Litems so that they can devote the time and attention and energy that they need to these cases. And we are committed to providing Guardian Ad Litems with robust training. As you heard from the public defenders, the kinds of issues that guardians face on a regular basis include chemical dependency issues, domestic violence, mental health issues, and obviously child development is an important part of training, as well as the statutes that apply and the court rules and procedures and so forth. And we're also committed to trying to explore creative alternatives to meeting the needs of kids and resolving these cases in the best way possible. So I appreciate your taking the time to listen to us, and Suzanne, I think, is going to give you some of the nuts and bolts about the program.
Ms. Allegro.
Thank you. As you can see, we are a relatively new board. We are the result of legislation that was created in 2010, and the legislation moved the Guardian Ad Litem program out from the court system and put it under the independent board. The impetus for this was there has been discussion for years over the fact that whether the court should be administering a program, the Guardian Ad Litem program, where it could be construed that there were conflicts of interest or perceived conflicts of interest because the judges and the court administrators were housing a program that provides support and supervision to individuals who are party to a case. We are party to cases in the juvenile court. So for that reason, and the program was moved out of the court system. I will go over just very briefly some of the highlights of the Guardian Ad Litem program history. I think it's fair to say over the last 17 years, the program has had almost continuous change, and we've undergone some major revisions. In 1995, there was a legislative auditor's report that was conducted of Guardian Ad Litem services statewide, and at that time, the Guardian Ad Litem services were at the county level, county funded, and county administered. The legislative auditor's report indicated that there was little in the way of standards regarding recruitment, selection, supervision, training, no complaint procedure, no removal procedure. Basically then, in response to these complaints, the Supreme Court did set up a task force and later promulgated the rules of Guardian Ad Litem procedure to basically address these deficiencies. The next major milestone occurred when there was the state funding of the court system, and at that time, with state funding, the funding of the Guardian Ad Litem program was addressed so that some of the disparate funding around the state was made more uniform. At the time of state funding, as Judge Metzen mentioned, we do have federal and state mandates. In 2001, prior to state funding, we were only meeting those mandates 55% of the cases. The next major milestone occurred, and which was the impetus for the legislation, that the Judicial Council did set up a committee to look at the long-term challenges facing the program, and two recommendations came out of that the Judicial Council task force. One was to seek the legislation to move the program out from the court system and under the independent board. The other was, at the time, a Guardian Ad Litem could either be a volunteer, a state employee, or an independent contractor. Volunteers are used primarily in Hennepin and Ramsey County and only in juvenile cases. The Judicial Council decided that we would no longer use independent contractors. So at the same time, the board was moving, or the program was moving from the court system under the board, the employees, we set up the employee model. So we no longer use independent contractors as Guardian Ad Litems. Just a couple of things regarding the structure. As you know, we are in the judicial branch. However, we're not subject, the board is not subject to the control of the judiciary. We do have 7 members, 4 appointed by the governor, and 3 by the Supreme Court, and the chair is appointed by the Supreme Court. One of the other things, the legislation did set certain requirements for board members that they do need to be knowledgeable about the Guardian Ad Litem work. We could have no lobbyist or active judge, and that also there would be geographic representation on the board. The board does have both mandated.
We have copies. I don't know what happened,
Okay.
but you'll have to keep
Okay,
going.
I'll just, okay. We do have, the board does have both mandated duties and permissive duties, and I've outlined those as part of the PowerPoint. One of the things, the board does typically meet on a monthly basis, and we meet here in the Twin Cities, but we've also had meetings out in St. Cloud, Duluth, Bemidji, Mankato, and this gives the, whether it's the public or the local judges, the opportunities to come meet with the board and see what we do, and also if they have issues they would like the board to discuss. In addition to the duties, a couple of things that the board has focused on since they came into existence. One is quality assurance. We want to make sure that we're doing a good job, and so we did do a stakeholder survey. While the results were positive, there were certain areas that we wanted to focus on. These include child contacts, the number, and also the independence of the Guardian Ad Litem. Additionally, we're working on a major revision of the report format that the guardian ad litem presents to the judge. We want to ensure that the focus of the report is indeed the child, because that's the guardian's role to advocate for the child's best interests. The other thing, the board, in wanting to ensure that it carried out its fiduciary responsibilities, we did hire a CPA firm to do a financial audit of the program, to look at reviewing payroll, expenses, contracting procedures, that type of thing, and we hope to have those results in March. The board has adopted 3 strategic issues, one dealing with structure and procedures, another dealing with obtaining our necessary resources, and I think also, as Judge Metzen mentioned, one thing very important to us is to encourage alternative approaches that best serve the children. In the material that is, we did provide to you, the handout, we have listed a number of initiatives, some samples around the state that the different programs are involved in. Also, as the judge mentioned, we do operate under both federal and state mandates. Our federal mandate is what's referred to as the CAPTA legislation. That was originally passed in 1974, and basically indicates that a state must enforce and enact laws mandating the appointment of a guardian ad litem in every juvenile case alleging that a child has been abused or neglected. Over the years, the CAPTA legislation has been reauthorized. The latest time was in 2011, and there was bipartisan support to reauthorize CAPTA. We also operate under state mandates. The mandate for our juvenile court is in Minnesota Statute 260C16, and then we also have a mandate in family court where in proceedings for child custody, marriage dissolution, if the court has reason to believe that the child is a victim of domestic abuse, then the judge shall appoint a guardian ad litem. That same statute also provides for the permissive appointments of guardian ad litem where the custody or parenting times are an issue. The court may appoint a guardian ad litem. The guardian ad litem does have a number of duties that are statutorily mandated, and those have been included in your packet. The statutorily mandated duties are the same whether the guardian is working in family court or in juvenile court. Additionally, we have included in the packet the minimum qualifications for a guardian ad litem to be hired, and also these minimum qualifications also, though, apply to our volunteer guardians. And one of the things I would like to point out is we also, per statute, employees and volunteers are required to undergo the BCA and federal background check. We also, over the years, we've got questions about our training, and I have included some information about the training requirements. We do have four core training programs. One is our juvenile pre-service, that's 40 hours. Domestic violence is 6 hours, and those 2 courses are required for any guardian ad litem in the program, again, whether employee or volunteer.
We're going to interrupt you for just a second. Representative Moline.
Thank you, Madam Chair, and to the testifier. Just, I know you're going to go through some of the training, but as to the qualifications, slide 12 says a BA or BS in psychology, social work, education, nursing, law, or child-related discipline, or have an equivalent combination of training, education, or experience. And I was just wondering if you could outline what you consider to be equivalent to a bachelor's degree in those specialized areas, and if that is a statewide standard.
Ms. Allegra.
Madam Chair, Representative, these standards are statewide. They apply to any of the 10 district guardian ad litem programs. I think what the equivalent we'd look at is if somebody had work experience in those particular fields that would be equivalent to the degree.
Representative Moline.
Thank you, Madam Chair. And I guess just to follow up, I mean, is there a certain length of time that they had to work in that related field, or is it just sort of a case-by-case basis of what that person might have in order to qualify as a guardian ad litem, or is there some sort of standard that you set?
Ms. Allegro.
Madam Chair, Representative, we don't have an actual number of years of experience for a BA or a degree. I will say most of the recent hires that in the last several years, and especially since we've moved over to the employee model, do have a BA degree, or we have a number with master's degrees, and we have a number of lawyers in the program as well.
Representative Moline.
Thank you, Madam Chair. And I guess just a quick follow-up is, looking at the guardian ad litem duties and then what your qualifications are. I mean, do you feel like your duties sometimes overlap with the social worker that's already assigned to the case? Because, if you have a social worker who, they're usually looking for the best interests of the child as well, they have to meet some other requirements too. But to me, it seems like to have a social worker assigned to a case and to have a guardian ad litem who may be a social worker, may not be a social worker assigned to the case, maybe a lot of times that's two people doing the same thing. And I was wondering if you could just comment on that.
State your name for the record. Go ahead.
My name is Melissa Olson, and I am a guardian ad litem in the 4th Judicial District. I think that's a very, Madam Chair and Member Moline. I think it's a very valid question. Oftentimes, in Hennepin County, there's a child case manager assigned. So in addition to the child protection social worker, Hennepin County assigns a child case manager. What we find is that we do very different jobs. The child case manager really has to be concerned with the day-to-day services that are provided to that child. And they typically don't comment on whether or not the services are necessarily the appropriate services or whether those services are working for the child. That is something that is typically done by all parties, but especially the guardian, in keeping with the best interests of the child.
Representative Moline.
Madam Chair, I'm sorry, just a quick follow-up would be maybe to the judge. If a guardian ad litem gives a recommendation to the court on what should happen with the child or the family, and the child protection worker gives a recommendation that differs from what the guardian ad litem had recommended to the court, is it up to each individual judge what weight they give to each of those opinions?
Madam Chair, Representative Moline, I'm sorry. As in any case, as a judge, you weigh the arguments that are made on both sides. Oftentimes, the social worker is driven to a large extent in their recommendations by the cost to provide certain services for a particular child or family. And that certainly is a consideration that judges have to make. What's the basis for the guardian ad litem's recommendations? I would just question, as you're doing, I would be asking some questions about, well, why are you recommending that as opposed to what the social worker is recommending? And sometimes as a judge you would adopt the recommendations of the social worker, sometimes you would adopt the recommendations of the guardian ad litem. But it's another voice that's an important one to be listening to as a judge.
We're going to have much more conversations about guardian ad litem, so if we could just finish the presentation. Ms. Allegro.
In wrapping up a little bit, on page 14, I have included some additional information about the program. We currently have 10 guardian ad litem programs in each judicial district. The breakdown is 71 full-time employees, 148 part-time, and 385 volunteers. And as I mentioned before, the volunteers are primarily used in Hennepin and Ramsey County. We do, as you can see, employ a large number of part-time employees, and these are basically outstate Minnesota, and this is in response to certainly the caseloads in each of the counties. Our two-year budget is $24 million, and at this point we do have a 99.991% compliance with our federal and state mandate to provide a guardian ad litem. On page 15, I've included some caseload information from 2011. We will have our 2012 data available later this week. But just to give you an idea, in 2011, we handled about a little over 6,000 new cases. The breakdown of those is 3,700 juvenile, 2,400 family, and 30 other. And within the family court, about 950 of those were domestic abuse cases. And during that year, a little over 9,000 children were represented by the program. The guardian ad litem spent an average of 60.22 hours on a CHIPS case, child in need of protective services, and we were able to assign about 84% of our cases to a guardian within 3 days.
Any other questions? Representative Driscollowski.
Thank you, Madam Chair. Judge Metzen, just wondering, could you just briefly outline for us those state and federal mandates to have a guardian ad litem?
Judge Metzen.
Madam Chair, Representative
Driscollowski.
Briskowski, sorry.
Briskowski.
I can't see it there. Briskowski, thank you. Federal law requires that where federal dollars are expended for kids in foster care and so forth, that you provide a guardian ad litem in those cases. And state statute also requires guardian ad litems in every case where a child is petitioned to be in need of protection and services. So where the county brings the petition, and in all of those cases then where there are allegations of abuse or neglect, we're required to provide a guardian ad litem.
Ms. Allegro.
Madam Chair, I would also, if we do have time, Ms. Olson, in response to some of the questions, could provide some talk about a case and sort of what the guardian ad litem does, if you feel that would be helpful.
Go ahead. State your name for the record.
My name is Melissa Olson. Madam Chair and members, I've just come today to talk a little bit about the work I do as a guardian ad litem in the 4th Judicial District. And I'm briefly going to talk about a case I've had and touch on some of the subjects that have been brought up, particularly the independent voice of the guardian ad litem and some of the alternative approaches that are taken or undertaken by guardians in each case. I have had a case with a 15-year-old who'd been in and out of foster care since about the age of 9. After his father passed away, just recently he'd been reunified with his mother about 2 years ago, who he'd not lived with since he was an infant. The case came into Hennepin County because mother and son were living together in an emergency shelter, and it was determined that parent and child could not stay together given the mother's chemical dependency problems. Now, the teenager is a gifted musician, having taught himself how to play the guitar for the past 2 years. Generally, people really like and respect this young man, but because he has a history of abandonment, he's had a very hard time sustaining basic relationships, including some with social workers and other folks at school like teachers and so forth. If I leave you with nothing else today, it is that every child comes into our child protection system with a story to tell, and it is often the guardian ad litem who helps that child tell his or her story and translate that story into meaningful services. In terms of placement, this 15-year-old had been on run from 3 foster homes, and after having been on run, was recommended to residential treatment for 35 days. And the recommendation was for him to stay there for up to 9 months. While he was there, one of the things his mother was able to do for him was approach a community service provider and ask if he could go on what was essentially a 3-week camping trip. The department dismissed the idea out of hand. They said he can go camping when he's back at home and when the case is closed. However, I knew of the community program. I knew the service provider really well, and I knew that there was a therapeutic element to this particular program that was very strong. And so I was able, as the guardian, because I'm a party to the case, to bring workers, family, the child, and everybody who had a stake in the case together to talk about the possibilities for him engaging in this program. And so we did that. And what ended up happening is that after this trip, he had formed a relationship with the service provider. He's an older male that he could relate to and start to talk about some of the things that he's experienced. And it was really that relationship that allowed him to exit the residential treatment facility. He could have been there for 9 months. He was there for 3. And as a result, he got permission from the judge to be able to do all this. We brought this to court. We presented it. And the judge was very much in favor of all of this. So as a result of leaving the RTC, the Residential Treatment Center, he was able to go back, start school this year, to really communicate some of his needs to his parent, with all the help of everybody involved, but in particular the community service provider, and has been going to school on a regular basis for the past 4 months while living at home reunified with his parent, which was the ultimate goal and is the ultimate goal of the department. So in this instance, I was able to really say, let's look at all of the opportunities here. Let's think outside the box. And that was really the alternative approach that worked for him and ultimately has served his best interests. And I think we're all better off for that. We have a 15-year-old who's living in the community and is doing much better today. As for the mom, she worked hard with regards to her sobriety, and the department was really able to help meet her needs in relation to her son. And that is really a part of what the social workers in Hennepin County are tasked with doing, is really working with the parents in the best interests of the children. So there are really 1,000,001 reasons every day in which gals make the difference in the lives of children and families, whether that's helping a kid tell their story or making decisions along with the county and the Department of Health and Human Services that are in the child's best interests. With that, I'll close. Thank you.
Thank you. Thank you. The next presentation we're having is from Sentencing Guidelines. Members, we did locate the letter from the public defenders. That's being passed out currently. We're going to try to get the computer to work again so that it's prepared for the next presentation. Otherwise, please come to the table, state your name for the record, and if you could try to present while he gets the computer to work, we would greatly appreciate it.
I'm Kelly Mitchell, Executive Director for Sentencing Guidelines, and with me today is Jeffrey Edblad, the Chair, and he's going to start off for us. You should already have a copy of the presentation that's in blue.
Thank you. Is it Mr. Edblad?
Yes, Madam Chair, members of the committee, good afternoon. My name is Jeff Edblad. I'm the Chair of the Minnesota Sentencing Guidelines Commission. The Minnesota Sentencing Guidelines Commission was the first sentencing guidelines commission in the country created by the legislature in 1978. We are a sentencing guidelines system that provides the legislature with a structure for determining and maintaining a rational sentencing policy structure and system. Through the development of the Minnesota Sentencing Guidelines, the legislature determines the goals and purposes of our state's sentencing system. And our guidelines generally represent the goals of the criminal justice system and specifically recommend the appropriate sentence for an individual based upon that individual's criminal history and the severity level assigned to that offense. The Minnesota Sentencing Guidelines Commission is an independent 11-member body created by the Minnesota legislature, where 8 members are appointed by the governor. They are the Commissioner of Corrections, Tom Roy, a peace officer from the state of Minnesota, currently Sergeant Paul Ford of the St. Paul Police Department, a county attorney, currently myself in my capacity as the Isanti County Attorney, a state public defender, currently John Stewart, the state public defender, a probation officer, and that seat is currently filled by Jason Anderson, a member of the Department of Corrections out of the Grand Rapids office, and 3 citizens, one of those citizens having been the victim of a felony-level crime. And our citizen representatives are Yami Vang of St. Paul, Sarah Walker of St. Paul, and Connie Larson of Waseca. Also, on the commission are 3 members who are appointed by the Chief Justice of the Supreme Court. Currently, they are Justice Christopher Dietzen of the Minnesota Supreme Court, Judge Heidi Schellhaus of the Minnesota Court of Appeals, and Judge Caroline Lennon of the 1st Judicial District. A major responsibility of the Minnesota Sentencing Guidelines Commission is to maintain the guideline structure by annually modifying the sentencing guidelines. We do this by responding to a number of areas. First, we respond to legislative changes. When there are new crimes enacted by the legislature, we respond to those actions by addressing and ranking those crimes on the sentencing guidelines. When a crime is amended in some capacity by the Minnesota legislature, we also respond by modifying the guidelines to address the amended crime as provided to us by the legislature. We also react as it relates to issues raised by concerned parties, by our partners in the criminal justice field, issues that come to us from victim services groups, issues that come to us from practitioners, prosecutors, public defenders, probation officers who are in the trenches and seeing the issues unfold will often bring these issues to our attention as well for us to address through the annual modification process. And we also address modifications of the guidelines through court opinions. We monitor the court of opinions from our appellate level courts that address sentencing and sentencing guidelines issues, and based upon the opinion or specific decision, we will make modifications of the guidelines that are affected by that opinion. And I will turn it over to Ms. Mitchell in a second, but our responsibilities also include evaluating the outcomes of changes in sentencing policy. We deal with the fiscal notes that provide the legislature detailed analysis of the impact on adult offenders from introduced bills. We're responsible for providing reports as requested by the legislature and other policy members and policymakers. We provide an annual report to the Minnesota legislature every January 15th. We're also responsible for analyzing trends and making appropriate recommendations. We monitor data and maintain data on all offenders convicted of a felony offense and are sentenced under the guidelines, and we have this information going back to 1980. We also publish reports on annual summary statistics and crimes of interest, including assaults, dangerous weapons, criminal sexual conduct offenses. And we also are responsible for the ongoing education of those in the criminal justice system by providing educational opportunities, seminars, and trainings on sentencing law and policy. And I will turn it over to Ms. Mitchell at this time.
Ms. Mitchell.
Thanks. I'm Kelly Mitchell, Executive Director of the Sentencing Guidelines Commission, and I'm going to spend a few minutes just talking about what the guidelines are, taking a step back to talk about what they are, and then I will highlight some of the work that the Commission can do, that we do regularly and that we can do for you. So just as a basic point, the sentencing guidelines are a determinate sentencing structure designed to promote public safety and uniform and proportional sentencing for felony offenders. There's a lot of concepts rolled up in that one sentence, so I'm going to go through those now. So first of all, it's a sentencing structure. In Minnesota, that structure takes the form of our sentencing guidelines grid. And the grid basically establishes appropriate sentencing based on both the severity of the offense and the criminal history of the offender. The severity is the vertical axis on the grid. The further up you go, the more serious the crime is. The criminal history is the horizontal axis on our grid. The further out to the right you go, the more criminal history the offender has. It's also a determinate sentencing structure. A determinate sentence is simply one where the where the sentence is defined in length, and a parole board or other agency can't change that on the back end. This is different from indeterminate sentencing, which we had prior to enacting the guidelines, where in that case the legislature would establish a high maximum penalty, the judge would make the decision who goes to prison and who doesn't, and what the upper range of the sentence could be, and then the parole board would decide when the offender could be released. Here instead, we use our grid to establish what the appropriate sentence should be for the offender. That sentence is known up front, and then under statute, if they receive a prison sentence, we also know that they're going to serve 2/3 of that time in prison and 1/3 of that time on supervised release. Just reminded me that I forgot to show you one thing about the grid in case you're not familiar with it. On the bottom half of it, we have some shaded boxes that are darker than the rest. And what that means is what you do is when you have an offense, you find the severity level, the criminal history of the offender, and you match it up. So wherever those two intersect on the grid, that's your sentence. If it falls into the shaded area of the grid, the presumed sentence is probation. If it falls into the white area of the grid, then there's going to be a prison sentence that is presumed. The number on the grid represents the number of months that the guidelines are recommending should be served for that offense. And within the white area, we have a range that's also 15% lower and 20% higher than that presumptive time. And if the judge sentences anywhere within that range, then the judge still is following the guidelines.
Representative Black.
Thank you, Madam Chair. Ms. Mitchell, when we phased out determined sentencing in the late 70s, when did we accordingly phase out the parole board? Can you tell me?
Madam Chair, Representative, the parole board was eliminated at the same time, but we still have offenders that were sentenced under that old regime. So there are occasionally offenders that need to come before some authority to have their parole, their release decision made for them. And I believe that the Commissioner of Corrections serves as that release authority now.
Okay, Madam Chair, Ms. Mitchell. Didn't we, in 2006, after the Drew Shadeen incident, reintroduce indeterminate sentencing for certain sex offenses?
Ms. Mitchell?
Madam Chair, Representative, yes, there are offenders under the who can be sentenced to up to life. And it's a determinate amount up to life. It's a particular amount up to life. And so, do you know how that? I know, that's kind of embarrassing, but I'm not sure. I think that the Commissioner of Corrections is currently our release authority for anyone who has an indeterminate sentence, but I would have to verify that for you.
Okay, Madam Chair.
We'll get you some information, Representative.
Thank you. One more question, Madam Chair.
Representative Black.
Thank you. How many other states who operate with some version of indeterminate sentencing do not have a parole board, but just cede all their indeterminate sentencing authority to the Commissioner of Corrections? Can you tell me that?
Ms. Mitchell?
I don't know the answer to that, but I could look into that if you'd like.
That'd be great. Thank you.
Mm-hmm.
Ms. Mitchell?
Okay, so moving on here. So I mentioned it's a determinate sentencing system. It's also a structure that promotes uniformity and proportionality. Uniformity just means that offenders who are convicted of similar types of crimes and who have similar criminal history should receive the same sentence. So that's how the grid cells come into play. Proportionality simply means that the severity of the sanction should increase in direct proportion to an increase in the offense severity or the convicted felon's criminal record, or both. So that just means as you move up the grid or over to the right, the sentences, you'll move from probation to prison, and the length of the sentence will get longer. Our structure also is there to promote public safety. Public safety is the main consideration underlying our sentencing structure. It's directly stated in our enabling legislation, and it shows up in the structure of our grid. As the severity level increases, the presumptive sentences increase, establishing that more serious and violent offenders should go to prison, while less serious and nonviolent offenders should receive probation. These are a couple additional goals. They weren't in that one sentence that I gave you at the beginning of my presentation, but these are stated on the very front page of our sentencing guidelines. And the first one is the sentencing should be neutral with respect to race, gender, social, or the economic status of convicted felons. We strive for that at the Commission. We look regularly at whether sentencing practices impact a particular group. And here at the legislature, if there is some proposed legislation that we think, that we can tell will have a direct impact on a particular racial group, we will let you know that with a racial impact statement. Capacity, the second principle here is that prison and jail capacity is finite and should be reserved for those convicted of more serious offenses or for those with longer criminal histories. The capacity constraint is a very real one. We help you take that into consideration by providing you fiscal notes that tell you what the prison bed impact will be of any proposed legislation, new felony offense legislation or amendments to current felony offenses. We also assist the Department of Corrections in projecting the prison bed capacity annually. So a little bit about how all of this works today. I like to think of the guidelines as a series of policy decisions. First, the legislature defines the offense and establishes the penalty ranges in statute. That's your job. You tell us what is a criminal offense and what that maximum penalty should be. Using that as our guide, the commission then determines the severity level for each offense. So we rank it on the grid. The commission also determines what goes into that criminal history score, the number that's along the bottom. Right now, it's prior felony level offenses, custody status at the time of the current offense, whether they were on probation, for instance, prior eligible misdemeanor or gross misdemeanor offenses, and prior juvenile offenses. So it's a conglomerate of all of that information that goes into criminal history. And then severity level and criminal history together determine whether the offenders should receive prison or probation and how long their prison time should be if that's their sentence. But the guidelines don't work in a vacuum. The integrity of and impact of the guidelines is also influenced by their application. So prosecutors make the initial charging decision, and that conviction offense establishes the potential severity level of the offense. Probation conducts pre-sentence investigation reports, and during that process, they may make recommendations to the court as to whether the guidelines sentence should be followed or whether there's something else that should be taken into account for that particular offender. And in some cases, plea agreement might be negotiated, and sometimes that might be for a guilty plea to a lesser offense, which would change the potential sentence to be given. Victims have an opportunity to comment regarding the appropriate sentence, and the court may accept or reject the plea agreement, or they may depart from the sentencing guidelines. Another factor that comes into play with regard to sentencing guidelines are statutory mandatory minimums. So these are minimum sentences that are established here at the legislature. So a good example that I have here is assault in the second degree. We have that ranked at severity level 6. So if you were to look at the grid, if the offender had a criminal history score of 0, 1, or 2, the grid would dictate probation, but there's a 36-month mandatory prison sentence on the books in statute. So that overrides the guidelines, and that mandatory minimum is the presumptive sentence in that case.
Excuse me, Representative Hartman.
I have a question. On slide 13, you said in many cases prosecutors and defense attorneys will come up with a plea agreement. Do you look at the racial disparity issues that come up with the plea agreements, or do you only look at, when we're looking at creating a new offense, with the, whether that would have an impact different by race?
Ms. Mitchell.
Madam Chair, Representative, we actually don't have data on when a plea agreement occurs in a particular case. So we are basing our estimates on how the offenses have been sentenced in the past. So, for instance, if it is brought down, or if the agreement is to plead to a lesser offense, we know that they were sentenced to that lesser offense, but we don't know what the original charge might have been and what the impact of that plea agreement might have been.
Representative Portman.
Do you know if there is an entity that collects that data?
Ms. Mitchell.
Madam Chair, Representative, no, I don't. It's possible that the courts might have some data, but I don't think that they analyze it on a regular basis in that way.
Thank you.
Ms. Mitchell.
And then the final piece that comes into play with the guidelines are departures. And I just want to let you know the guidelines are there for the typical case. So it's presumed to be the appropriate sentence most of the time. But there are situations where the offender's individual situation might need might need to come into play and might be a reason that the judge should depart from the guidelines. And to depart just means to pronounce a sentence that's different from the sentence recommended under the guidelines. So that is part of the overall picture of the application.
If I could just ask a couple questions about that. So there's both a dispositional and a durational departure. So a judge could say, I'm not going to send you to prison when the guidelines say you should, or I'm going to send you to prison for a shorter period of time. Do you then track that data? How do you track it? Do you track it by judge? Do you track it by offense? Do you track it by county? How do you keep track of those departures? Ms. Mitchell.
Madam Chair, we track it every single way you just mentioned it. So we basically get the entire sentence for every felony conviction and all of the data that comes along with it, where, what judge it was before, all of that data. So basically, once we have that, we can sort of slice it and dice it in many different ways. We tend to look at it overall, and then we tend to sometimes look at it, by offense. We could tell by offense what the departure rates are. We can tell across the state what the departure rates are in a particular judicial district. So, in fact, some of the next slides that I have will show some of those different ways that we can put the data together for you.
Thank you, Representative Wiskowski.
Thank you, Madam Chair. Along that line, is that data that you mentioned, those departure data, is that public data?
Ms. Mitchell.
Madam Chair, Representative, yes, it is public data.
Thank you, Madam Chair.
Ms. Mitchell.
So what I wanted to do over the next couple of slides was to actually show you what we can do. So you've heard a lot about the policy end of it. That determines what appropriate sentencing practices should be. The other half of what we do is to monitor those actual sentencing practices so that we can follow and understand how the policy decisions of the legislature and the commission are applied. So I'm going to lay out some of the basic trend data in the next few slides, and then I'm going to actually skip through some of it so I can show you how we can dive in deeper into a particular topic. Even though I'm going to skip some slides here, we filed our report with you last week. Everything that I'm showing you here is in the report, and so all of it is more fully explained there, and I'd be happy to answer questions later on if you have any.
Thank you.
So, for example, in 2011, here's a picture of the number of offenses sentenced for felony convictions over time. In 2011, there were 14,571 felony offenders, and you can see that since the guidelines were enacted in 1981, we've seen quite an increase from 5,000 offenders back then to over 14,000 offenders today. Some of the more recent increases occurred from 2002 to 2006, when that was our most recent spike before things started to level off. And that spike was attributable to the enactment of the felony DWI law and increased sentencing for drug offenses, particularly methamphetamine cases. And both of those trends have leveled off, and so that accounts somewhat for the dip that you see after 2006. Here's just a picture of how those offense types break out, or how those offenders break out by offense type. One of the more interesting things that you can take from this particular slide, if you look at the red band along the bottom, you'll see that it's been on the rise for pretty much the past decade, and a lot of that increase is actually due to an increase in domestic assault-related cases. Not necessarily that there's more cases, but that there are more felony-level domestic assault cases. Some of those previously were chargeable only at lower-level offenses, and the laws were changed to make those felonies, and so we've seen the corresponding increase in person offenses. Another area, the green is property offenses. That's actually an area that's down recently. It accounts for 29% of the volume in 2011. Purple are drug offenses, and those account for 23% of the volume in this past year. And then the blue area, the blue band, is an area that's increasing as well. We call that our other category. It's sort of everything else. But that includes DWI offenses, pornography, fleeing a police officer, and it's pornography is one of the offenses that's driving that one up. It's really a small number of cases overall, but it's increasing dramatically within itself, so it's showing quite a big rise there.
So if I could ask, so this is the cumulative amount, so 100% of the cases then are covered by the bar, and so property cases and drug cases are down. Pornography was up, and then it went down, and then now it's back up. Is that how I'm reading the?
The other category sort of went up and down, and now it's back up.
Right,
but there have been different things that have driven the other category over time because there are many different things in there.
But person crimes are up in 2011, property crimes are down, and drug crimes are down. Is that the way I read this, Ms. Mitchell?
Madam Chair, the person crimes are up, property's down. Drug crimes went up slightly, about 2% over the prior year. But they had been going down every year prior to last year, so that's why it looks like there's a downward slope.
Thank you. Ms. Mitchell.
This is just a picture of felony offenders by race over time. So you can see that our population has changed quite a bit since the guidelines were first enacted. From 1980 to today, the percentage of proportion of offenders who are white has decreased by 25%, and the proportion of offenders who are minorities has increased and taken up a greater percentage overall. This is a statistic that shows the total incarceration rates for 2011. I'm just going to have you focus in on that very bottom page, the very bottom line that says overall.
Excuse me, Representative Paymer.
Well, I want to have a question on this slide, but I'd like to hear as soon as she's done with the slide.
All right, Ms. Mitchell.
Madam Chair, thank you. The overall, first of all, incarceration, as we are reporting it here, includes prison and jail. So the overall incarceration rate is 90%. So 90% of felony offenders sentenced in 2011 received some type of incarceration as part of their sentence. That breaks down to 25% receiving prison and 65% receiving some amount of jail time. So.
Madam Chair.
Representative Paymer.
So this two-part question, I guess, is what does the Sentencing Guidelines Commission think about the relatively high disparity of people of color who are incarcerated in prison relative to the white population? And that's the first question, and then I'll have another question.
Ms. Mitchell.
Madam Chair, Representative Paymer, there are a lot of factors that go into that number. It is that the incarceration rate is higher for black offenders than white offenders. To really understand that number, we have to then look at where are the offenders located, what types of offenses were committed. It may be appropriate if the offenses were higher severity offenses. And what the criminal history scores of the offenders were. It also may be appropriate if these offenders had higher criminal history scores. That would take a little bit more of a presentation to dive into to see if there's really anything going on there. But there are a lot of factors that go into that number.
And would you be capable of putting together something to take a look at that if you were given a long period of time to do that?
Yes,
Mitchell.
Well, Madam Chair, I guess that's what, I would, whether your committee does it or we do it together or we do it. Representative Lesch asked the question about, I always thought that the rationale for determinate sentences was to mitigate the racial bias in the criminal justice system, but, without understanding. I guess you could say that some of these crimes have a higher criminal history score, but on its face, it looks like simply that we're putting more people of color in prison, and it opens up a whole lot of questions to me, whether it's drug offenses, are people of color who are arrested for possession or sale of crack cocaine going to prison for longer periods of time than white folks who are selling or possessing regular cocaine, and all of those kinds of questions. I think it's a big public policy issue that since I've been here we seem to ignore, but I hope we don't going forward.
Representative Portman.
And I don't know if it makes more sense, Madam Chair, in this committee or in Representative Paymar's committee, but the Council on Crime and Justice has a lot of that data. And they do annually a continuing legal education seminar at the University of Minnesota where they really go into detail at the different points in the system where the disparate results start to happen. And the criminal history score, for example, is really different. If my kid gets arrested with pot, a different thing happens to him than if Representative Moran's kid gets arrested for possession of pot. And I think they have extraordinary data. So I guess I would encourage both chairs to talk to the Council on Crime and Justice and see if some of the data we're asking these folks to analyze, they maybe already have and have done some analysis.
Well, and actually, we have reached the time for our committee. Would you like to make a closing statement? We will be talking to you additionally between now and the end of session. So, Ms. Mitchell, any closing statement?
Madam Chair, thank you. I just want to point to, there are a few slides at the end of that presentation that also point out that this is 10 years since DWI was enacted, and so we did a little bit of analysis on that for you, and I thought that just might be an interesting little tidbit for you, but just to demonstrate that we can go deep down into a particular topic or we can stay very high level. So we're here to provide whatever information we can to help you along your journey here.
Thank you. Members, any further announcements? With that, this meeting is adjourned.